Hi, my name is John Loughnane. I'm a lawyer at the law firm of Nutter, McLennan, and Fish in Boston. My practice area is in bankruptcy and distressed situations. But over the past several years, I've combined my interest in technology with the topic of data security. Bottom line, having seen my fair share of distressed situations over the years, I am a big fan of proactive action to head off disaster. And that certainly applies to the smart and proactive use of sound cybersecurity practices. Last summer, I prepared a tech report for the ABA. The second year in a row, I prepared such a report, picking up on the prior efforts of others. My 2020 tech report was published in the fall and can be found under the ABA Law Practice Division Publications tab. You can find my report along with several others under the Tech Report tab there on that page. My report focuses on the 21 questions in the ABA Tech Survey centered on security topics, including technology policies, security tools, security breaches, viruses, spyware, malware, physical security measures, and backup. If you want the details, I commend the article to you, or better yet, the survey itself. For today's purposes, I wanted to highlight 3 points. First, the ethical imperative of cybersecurity for lawyers. Secondly, current developments since the report was prepared. And finally, I want to discuss the essential takeaway from the tech report about the need for all law firms to have incident response plans. There clearly is much more to cover on the topic of cybersecurity, but in the 10 minutes or so allocated to me in this format, those are the 3 points I would like to cover. So let's get into it. First, ethics. As we all know, there are 3 fundamental ethical rules centering on competency, communications, and confidentiality. I won't summarize all the applicable rules here, but I do want to highlight the ABA Standing Committee on Ethics and Professional Responsibility Formal Opinion 483. That opinion came out in 2018 and is entitled Lawyers' Obligations After an Electronic Data Breach or Cyber Attack. There are 2 key points in that opinion, and I just want to mention them here briefly. First, the potential for an ethical violation occurs when a lawyer does not undertake reasonable efforts to avoid data loss or to detect cyber intrusion, and that lack of reasonable effort is the cause of the breach. Secondly, the opinion states that as a matter of preparation and best practices, lawyers should consider proactively developing an incident response plan with specific plans and procedures for responding to a data breach. In addition to ethical obligations of the profession, lawyers are bound as well, of course, to applicable state and federal laws governing information security and data breach obligations. And that is a point specifically recognized by Opinion 483. However, despite the ethical issues and pending challenges, the 2020 survey results reveal that the use of certain security tools remains at less than half of all respondents. For example, only 39% use two-factor authentication. Specifically, only 39% use two-factor authentication. And less than that have intrusion prevention and intrusion detection tools. Similarly, only 28% of respondents have remote device management and wiping tools, and less than that have device recovery and web filtering tools. In contrast to the continuing slow adoption of security tools, the results did indicate an increasing number of firms committing to cyber liability insurance policy. 36% of respondents, which is up from 26% in 2017. With the ethical imperative so very clear and the threat environment so pronounced, and the use of security tools not widely deployed, one apparent trend from these figures revealed by the 2020 survey is that the profession is seeking to cover risk through insurance. And certainly that's a good thing. Firms should have insurance policies in place, but an insurance policy alone will not adequately protect against cyber threats. As I noted in the article, the responsibilities and challenges could not be any clearer, and the profession needs more attention on the issues beyond merely increased insurance purchases. So let me get into the second topic, which is the incidents since I drafted the tech report. As noted, the report was prepared last summer, it came out in the fall, and the headlines keep coming, unfortunately, and predictably. Just in the past few months, there's been a few that I would like to highlight. Last month, Bloomberg Law noted that a major law firm was breached after a vendor used for large file transfers reported that it had been hacked. The firm reported that its investigation revealed that a small percentage of its clients may have experienced unauthorized access to or acquisition of confidential material. The firm indicated that it notified the impacted clients and also notified all firm clients about the breach. Back in the fall, multiple publications, including the ABA Journal, reported on another large firm that was hit with a significant malware attack. In that situation, the firm was hit with what it described as a sophisticated and aggressive malware attack. Monitoring systems detected the unauthorized activity. The firm found no evidence that client or firm data was accessed. However, many of the firm's systems were encrypted and shut down as a precautionary measure, and indicating that size is of no concern when it comes to data breaches. More recently, a smaller firm in Pennsylvania reported that it had been breached and that the personal health information of more than 36,000 patients of one of its large clients, a large medical center in Pennsylvania, may have been potentially exposed. And these are just three examples, and we can all be sure there are many more. And further, it's worth noting that this problem is not just confined to private attorney law firms, but also affects the United States court system. Specifically in mid-December, the Department of Homeland Security's Cybersecurity and Infrastructure Security Agency, CISA, issued an emergency directive regarding a known compromise involving a particular vendor's products that are currently being exploited by malicious actors. The Administrative Office of U.S. Courts immediately notified courts of the development, and in response, the judiciary suspended all national and local use of the IT network monitoring tool. Further information about this particular situation is available on the website of the Administrative Office of U.S. Courts. In short, nobody's immune. And now, before we get to the third part of my discussion, it's probably a good time for me to mention that I recently finished drafting another article that is due to be published soon by the American Bankruptcy Institute Journal. This article focuses on the real-life costs to a company that suffered a severe data breach. The company at issue was not a law firm, but I think the situation is worth mentioning here. You may remember the incident. It was about 2 years ago and concerned a receivables collection firm whose major customers included Quest Diagnostics and LabCorp. The collection business, which was very successful and highly profitable, ended up getting liquidated in Chapter 11, but not before the principal of that company spent millions of dollars in breach-related expense. I wrote that article to provide a case example of the actual costs that a breach can impose. So often, headlines hit with little publicity on the follow-up. I don't think my article will get anywhere near the publicity of the initial breach, but I do hope it helps as a case study for those interested in the actual costs of a breach. Certainly, if anybody wants a copy of that, please let me know. I'll be happy to supply it to you. Which brings me to the third point I wanted to cover now, incident response plans. As discussed in the tech report that I prepared, the 2020 survey reveals continued improvement by lawyers on the topic of developing incident response plans, with 34% of respondents indicating their firms maintain such a plan, up from 31% in 2019 and up from 25% in 2018. Incident response plans are a critical element of any effective information security program. The survey results clearly show an expanded adoption of incident response plans, yet there remains room for improvement. As I pointed out in the article, the LTRC has been conducting some form of the legal technology survey report for nearly 3 decades. We have to ask ourselves, how long will it take before every firm has in place a basic incident response plan? 34% is better than 25%, but given the important role that such a plan can play in effective security measures, the number needs to be much higher, given the ethical and legal issues discussed earlier, along with a heightened threat environment. Opinion 483 mentioned earlier should be a starting point for any firm tackling this issue. In sum, the 2020 survey largely reflects incremental progress in areas fundamental to adequate security in an age which cries out for a much more robust response by the profession to the challenges at hand. With 2021 now upon us, the ABA will be putting out the survey once again. Let's hope for continued improvement by the profession to the significant challenges of cybersecurity. Thank you.